Well, then we will move over to the one article, really, I guess. It says, this is from Courthouse News. This is a victory for those incarcerated. The story says Illinois inmates at the Will County Adult Detention Facility won a partial legal victory Monday with a federal judge in Chicago ruling that several of the jail's media and mail policies violate their civil rights. And what is the policy in dispute, Larry?
Oh, it's a good one. The a ban on photographs or other materials that are determined to contain sexual or other inappropriate content at the discretion of the mailroom staff. Sexual or inappropriate content policies, number one. A ban on all material printed from the internet, media articles or pages from books or magazines, like maybe our NARSO newsletter. That's banned. Number three, a ban on any mail from a person or publisher or business whose return address is a P.O. box, kind of like us. Regardless of the contents and regardless of the identity of the sender, there's the P.O. box ban policy. Now, can you at least admit that's funny?
That's totally 100% not funny because like the FYP transcripts come from a P.O. box, if I'm not mistaken.
So under the challenge policy, plaintiffs are still permitted to access a broad range of publications, the judge added. But
they're still permitted to access them. Like probably wouldn't all, not all, don't take that literally all, but don't all businesses run from P.O. boxes?
Many of them do. Yep.
U.S. District Judge LaShonda Hunt, a Joe Biden appointee, found the jail placed unconstitutional barriers on inmates' access to certain forms of media and mail sent from P.O. boxes. However, the judge allowed the jail's ban on sexual and inappropriate material to stand. How did this case come about?
A Will County inmate first sued the jail, and it's located in the Chicago suburb of Joliet, on a civil rights claim in 2017 after he was denied mail because of the jail's media restrictions. These included, among other things, all those things I read, and the P.O. box. And in September 21, U.S. District Judge Andrea Wood, another liberal pointy-headed Obama appointee, certified a class of current and future Will jail county inmates. She gave this case class action status certification.
By that point, the inmates had expanded their claim to challenge unreasonable delays in the jail's mail processing and its ban on sexual content and other materials deemed inappropriate by mailroom staff. One inmate representing the class said the jail used the inappropriate rule to confiscate pictures of his wife. The inmate who originated the 2017 suit said in a separate filing he was unfairly denied a book on the history of tattoos based on the same rule. So what happened next?
Both the inmates and the jail moved for summary judgment, and Hunt issued her split decision Monday.
Wow. How did Judge Hunt decide the case then?
Well, she decided using the Turner test, and that was based on a 1987 Supreme Court case, Turner versus, whatever that is, safe. You tell me what that is. Anyway, to evaluate the
safely.
In Turner, the High Court upheld restrictions on correspondence between inmates at a Missouri jail, but also found inmates had a constitutional right to get married. The Supreme Court has explained that prison walls do not form a barrier separating prison inmates from protections to the Constitution. Judge Hunt wrote, "The First Amendment is no exception to that rule."
The First Amendment is no exception. The Turner test is a 4-factor standard meant to evaluate whether a prison regulation is justified and whether there are workable alternatives if a regulation negatively impacts prison staff or inmates. Applying the Turner test, Hunt concluded that the jail's ban on internet materials and other media content isn't justifiable. Hunt agreed that the jail has a security interest in banning certain content. It argued the bans were necessary to stop prisoners from fighting over personal beliefs, gang affiliations, and sexual preferences inferred from each other's media consumption. But those security concerns do not outweigh the inmates' rights, especially as Hunt found the jail could still review the media the prisoners have access to.
Yes, Judge Hunt stated, in sum, although the first Turner factor is satisfied, the court finds the media policy falls short of the remaining 3 factors and is unconstitutional. She was even more skeptical of Will County's ban on mail coming from P.O. boxes, further finding that as applied, the rule violates prisoners' right to receive literature. Under the Will County Adult Detention Facility's current mail policy, P.O. box mail is even denied when it comes from identifiable sources.
We said just a few sentences ago, that they're trying to prevent people from getting into fights over their personal beliefs. I'm trying to figure out, is that a way to say religious beliefs?
Yes, that would be
Which
that.
certainly happens, but like, how do you deny people to have from their religious freedoms?
Well, therein lies the problem, and that's what Judge has slapped this jail down for.
All right, and well, you've pontificated that summary judgment can be good. In fact, you conceded that last episode that summary judgment worked in Guy Hamilton Smith's case in favor in the Kentucky case. That's the case where the state required all PFRs to identify themselves by their name on certain social media websites. Did it work in this plaintiff's case? Did it work in favor of them?
It actually did. Judge Hunt wrote, without more evidence, defendants failed to meet the burden of proving a compelling government interest and their policy that their policy's least restrictive means of furthering such an interest. So as a result, the court grants summary judgment in favor of plaintiffs against defendants on the RLUIPA claim, otherwise known as Religious Land Use and Institutionalized Persons Act. Now, see, this is what I talk about summary judgment. See, everything's the inferences are resolved in favor of the non-moving party. So the jail did not get to have their assertions about the necessity of their rules. All the inferences were resolved in the plaintiff's favor because they were moving for summary judgment for a different list of reasons. But so the jail didn't have any evidence in the record of how vital their policy was, and that cut against them. If you ain't got no evidence in summary judgment, you're not going to win the case. And I keep telling these attorneys somehow they have trouble understanding it. When you file for summary judgment, you're conceding that there's no material facts in dispute, and then every inference is made in favor of the non-moving party.
Chance, Larry has made it very clear what his opinion of summary judgment is. What is your opinion of it?
Well, it is what it is, which is usually a disappointment. That's my personal belief.
Do you ever seek it?
I don't, because I don't do that kind of stuff. I do criminal law, so I don't really engage in that. But every time I read about it, I see it. Generally, it means disappointment. Well, I don't think Larry would disagree.
I certainly don't. I love summary judgment when there clearly aren't any facts that can be disputed. But lawyers use summary judgment not in that limited situation. They use summary judgment because they want to move the case to a quicker resolution, and they don't want to offend a federal judge that's looking at them saying, "Counselor, can we work this out? Am I going to have to sit through a trial? Don't tell me that." I mean, the federal judges are very intimidating, can be very intimidating. And they don't want to disappoint the federal judge, so they say, "Oh, yes, Your Honor, we can have some stipulated facts." You might get the state to stipulate to some facts, but you're not going to get the state to stipulate to the facts that you really need them to stipulate to. They're just not going to do that. They're not going to agree that the registry is punitive. They're not going to agree to all the things that we need. So therefore, you're going to have to put on a trial. And I see case after case after case where if you read it, it says there was insufficient facts in the record. The record didn't support. We see that right here. This judge says that the record didn't support the summary judgment request by the defendants. So, I mean, hello? I mean, I don't understand what's hard to see. But anyway, we got to get this California corner in here before we run out of time.
You've been listening to FYP.